Good afternoon. Nice to meet you. Nice to see you.
Good afternoon and nice to see you.
I have one question. How should I put my presentation into the system?
How can you put it?
I had a problem last time, and I didn't manage to put it in the system.
If you want to share it on the web, on the screen, if that is the question, yes. Okay, yeah, and it's a good question. Now I try it.
It's still working, and it doesn't allow me to go further.
It's a good question. Presentation, maybe here.
Okay.
Somehow we previously could manage it, but now it is a good question. I have problems with this as well. Okay. At the bottom of this screen,
yes,
there is in the mid. There are 5 buttons, and in the middle, I think we can find one of them. Previously, it was a red one, but now there is something changed, and maybe via that we can do it. In the middle, there is a red button. Good afternoon for others.
Okay, thank you.
Good afternoon.
Good afternoon, Dr. Hornyak, as well.
Good afternoon.
Maybe now.
But what shall I do next?
I hope that can we see also Dr. Chesky here or not? Dr. Chesky, okay, yeah, okay.
No.
Okay, thank you so much. Okay, dear colleagues, be welcomed here at the 5th open seminar of the Polish-Hungarian Research Platform concerning the legal protection of farmers. On behalf, of course, of our research team and on behalf of the Institute of Justice in Warsaw, now, first of all, I would like to grab this opportunity and make an announcement. That is, our research team was successful and we could launch our monograph manuscript, to the IVS. All of us could successfully finished her or his a chapter in this monograph. And now we are waiting for the another step managed by the editor, managed by the team of the IWS. I think now we can focus on the second written form of our contribution, that is the chapters to another book. However, now in this open seminar, we are going to focus on our presentation. Some weeks ago, I started the order of the presentation. At that time, I started it with a quite new topic connected to the agricultural irrigation. That was the first part of my presentation. And now I would like to continue this presentation and a moment, and I try to share the PPT of this presentation. I do not want to repeat my previous presentation. However, I think that the present one can be understood without the sharing of the concept of the previous presentation some weeks ago. As to the present PPT, I would like to deal with these topics. First of all, the system of the legislation. It means the Hungarian legislation concerning agriculture irrigation. After that, I would like to focus on ownership affairs and management affairs and the planned operation of agriculture irrigation. The fifth point is connected to the costs and who bears the cost of the agriculture irrigation. And last but not least, of course, I would like to concentrate on environmental aspects of the agriculture irrigation, that is focusing on the sources of the water used via the agriculture irrigation. As to the first topic, the system of the legislation concerning agricultural irrigation, it is the legal background is quite complex. If you would like to understand the legal background, we have to assess, analyze 30-40 pieces of legislation. Therefore, it's, as I previously mentioned, it's a complex issue, and in this sense, it's a quite hard one. For example, as to the acts connected to this topic, I would like to draw your attention on the Cardinal Act on National Assets. Cardinal Act, it is a type of the act in Hungarian law. This kind of acts, they are adopted by the 2/3 majority of the Hungarian parliament. As a kind of comparison to the so-called normal act, of course, this normal act shall be adopted by the majority of the Hungarian parliament. Okay, there is a Cardinal Act about national assets, and it's an important background for our issue. There are numerous acts regulating this topic, of course, the environmental issues, water management issues, specific organizations connected to water public organizations. For example, the Water Public Organization Act and the Act on Irrigation Management, all of them regulate specific forms and institutions connected to agriculture irrigation. Or, for example, another Cardinal Act on land transfer or Act on land protection. All of us have important role in this sense, and there are numerous decrees of government and ministers. From this amount of legislation, I would like to draw your attention to, on the Act on Irrigation Management. It is a relatively fresh act. It was adopted originally in 2019. However, until now, it was amended. It was amended essentially taking into account the experience deriving from the practice and execution of this act. And I think this is a quite, if I would like to emphasize and determine a kind of good practice from the Hungarian legislation, I think this is a good initiative. However, it's not an only Hungarian-made solution, because the Austrian solution served as a kind of role model for the Hungarian Act. In this act, we can find specific administration body, specific determination of irrigation areas, districts, or specific plans which has the competence to replace numerous other types of licenses. And this act also established a specific form of irrigation, a specific organization. This is the so-called sustainable water management communities. As I previously mentioned, I think it can serve as a good example, a good practice maybe for other countries as well. Going into details, as to the ownership affairs of agriculture irrigation, it's worth emphasizing that there are maybe three main categories of ownership affairs. The one of them connected to property owners, as private owners, if we can use this word, private owners, as a private law category, or local governments or the state as owner. And it's worth emphasizing that the most important parts of the agriculture irrigation system connected, of course, to the state and local government. However, other important elements also connected, owned by other actors. In this system, in this ownership system, I would like to emphasize that some parts of the state-owned water facilities, they are exclusive property of the state, and they are protected by the so previously noticed Cardinal Act of national assets. Maybe it's an important characteristic of the Hungarian legislation in comparison with other national legislation. As to the management affairs of agriculture irrigation, this system is quite difficult and complex. Maybe it is easier to understand if we start this understanding on the base of the ownership, that is, the management of the state property. This system is quite easy because the state property management it is by the relevant water management public directorate. Another category is connected to the management of local government-owned water and water facilities connected to agricultural irrigation. This system is more complex because this management is pursued by the relevant water management public directorate. It's not a surprise after the state-owned property, but there are other actors, for example, the previously mentioned water public organizations, or the Hungarian state's authority as a kind of irrigation administration body. They are the main actors, and they are manage the previously mentioned properties as to the state as public asset manager. That is the basis of the management of these agricultural irrigation systems. As to the local government-owned water facilities, there are other options. The first issue that is the relevant water management public directorate become manager of these water facilities by the initiative of the local government. In this case, it is a kind of donation of the local government, and there is an asset management contract. Another option is that this is the initiative of the directorate, and another institution, a water authority, is going to design via decision this status, this water management status. In this case, in the background, you can also find a kind of asset management contract. As to the water public organization, there is a contract. There is a contract between the given local government and a water public organization. As to the irrigation administration body, in this case, there is an asset operation and maintenance contract. It is a contract. And in this case, the water facility can be operated by the irrigation administration body itself, or as a kind of second option, by a new form, a new institution established by the previously mentioned Agricultural Irrigation Act, and that is the Sustainable Water Management Communities. What is the situation, taking into account that the water public organization, they also can own some water facilities. In this case, they can operate their own agricultural irrigation facilities itself, or it's also an option to operate it on the initiative of a directorate by a contract. As to other private owners, of course, they can operate their own facilities itself, or by a water management public directorate, or water public organization, or they can establish previously mentioned sustainable water management communities, and via these communities, these private owners, they can operate their own facilities. Last but not least, as to the management affairs, I would like to draw your attention to legal institutions. One of them is easement on land. In numerous cases, a landowner cannot operate an agricultural irrigation system only via its own property, but this private owner is forced to use the land of other owners, and the easement on land provide this legal institution via which this farmer can reach the demanded water. And another option, it is the use for public interest. In this case, the farmer uses not the land, but the existing irrigation facility of another actor. The Act on Agricultural Irrigation, adopted in 2019, introduced a planned operation of agricultural irrigation. As a first step, an irrigation administration body was established. It is a government body. The name of this irrigation administration body is the National Land Center. A kind of next step was the determination of the irrigation development areas. What was the goal of the legislator when the legislator determined this irrigation development areas, there were numerous goals. The one of them to help support agriculture farmers to build water facilities without hard administration burden. Via these irrigation development areas and plans connected to these irrigation development areas, the farmers shall not obtain all specific permits, but to focus only the plan of the irrigation development areas. There are these bigger units, the irrigation development areas, and there are typically smaller areas, units, they are irrigation districts. Another important player in this planned operation, they are these sustainable water management communities. These communities, they are established by the initiative of given farmers, and via the establishment of these communities, a given irrigation district is also determined. Therefore, the existence of the sustainable water management communities connected to the adoption of irrigation districts. That is the reason why you can read that the boundaries of the irrigation districts are designated, are determined via the establishment of sustainable water management communities. As you can see, these sustainable water management communities typically, because there are some exceptions, but typically they are cooperatives or they are companies. That is the typical form of sustainable water management communities. I previously mentioned that irrigation administration bodies, they have an important role in the operation of planned operation. It means that they have an important role in the establishment of these communities. However, this is the competence of the Minister for Agriculture to accept the establishment of these communities. The given plans connected to the previously mentioned irrigation development areas, they are made by the irrigation administration body as well, and they are approved by the water authority. And as you can see, an irrigation investment that complies with the valid irrigation development plans does not require any environmental, nature conservation or soil protection permit or authorization procedure. That is the reason why we can say that these plans can help the job of farmers, and they can provide a kind of support from the burden of administration, because it was not so easy for the farmers to in the previous period to gain separated permits, but now they can manage it via this irrigation development plans made by the irrigation agriculture administrative body. And that is the environmental district plans. They can be maybe prepared in two cases. The one is that where there is no irrigation development plan in force, Another option where there is such an irrigation development plan, but where it is intended to derogate from the conditions set out in the irrigation development plan in force. That was the reason why I mentioned that typically these irrigation districts, they typically are smaller than the irrigation development areas. However, as to the effect of these environmental district plans, the effect is similar to the legal effect of the irrigation development plans. Therefore, they can help the job of the farmers. As to the rules for bearing the cost of agriculture irrigation, in my opinion, this Agriculture Irrigation Act and introduced institutions, areas of agriculture, the specific institutions, they were a good step into a good direction to provide a support for farmers. In my opinion, as to the costs of agriculture irrigation, maybe there are some opportunities for decision makers to improve the present system. What is the situation here? We have to be aware that in this sense, there are some rules in the European Union law which provide a kind of limit how to determine the cost bearing of agricultural irrigation. First of all, it is the so-called full cost recovery principle determined in the Water Framework Directive. And according to this principle, there are three elements of costs, and the decision makers, they have to regulate these three pillars of the cost elements in the when they determine the cost-bearing rules. The financial costs, the environmental and inventory costs, they are all important elements of the full cost recovery. And besides, another important specific environmental principle, the so-called polluter pays principle, is also an important element of this. The first, taking into account these EU rules, in Hungary, the first question is the allocation of the cost. And in this sense, the situation is that the cost of operating and maintaining state-owned and state-operated water bodies and water installations are to be covered by the central budget up to the extent of public interest. That is, there is a limit of bearing the cost via the national budget, and this limit is the public interest and the extent of public interest. And besides, another important issue and aspect is connected to agriculture water service charge. As a general rule, anyone who uses agricultural water services must pay an agricultural water service charge to the service provider. It's clear. The question is the level of this and the amount of this charge. And here you can see that, however, the state may take over the irrigation water service charge as provided for by a specific decree. At this moment in this decree, we can find two pillars of the agricultural water service charge: a basic and a variable charge. And as to the basic charge, it is the half of this basic charge is paid by the state and the half is paid by the farmer. However, as to the variable charge, the farmer shall pay the full amount of the variable charge. Last but not least, or besides this service charge, there is a kind of environmental charge, a water resource charge as well. There are numerous advantages for the agriculture irrigation for the farmers. For example, the charge for agriculture irrigation is a water resource charge which the water user does not have to pay up to a certain amount. That is 400,000 cubic meter per year, for example, but there are other cases in which the agriculture farmers shall not pay this water resource charge. The situation is that at this moment, and in comparison, maybe with other parts of the world, that the Hungarian farmers they feel numerous cases as a challenge to pay the charges of connected to agricultural irrigation. However, it's worth noticing that Hungary water situation is quite challenging. I previously mentioned, for example, as to the length of different water facilities in Hungary is the longest in the European Union. That it means that the maintenance of this water management system, of course, is more expensive than the maintenance of other maybe water management systems. Last but not least, I would like to draw your attention to the sources or the potential sources available for agriculture irrigation. Typically, the legislator focuses on surface water and groundwater. It means that rainwater, for example, is not specifically addressed in the agriculture irrigation rules. And the most important sources for agriculture irrigation, of course, is connected to the surface water. And farmers, they can apply groundwater if they do not have any access to surface water. As to the groundwater, of course, there are different types of groundwater, and the most vulnerable part, they cannot be used for agricultural irrigation, and sometimes of groundwater can be used only via specific environmental friendly methods. Here you can see the details in connection with this. However, of course, in my second paper, I'm going to focus on the agricultural irrigation, especially emphasizing the good practice aspect of the Hungarian legislation and the potential way how to develop it. Dear colleagues, thank you so much for your attention. And now I would like to call my colleague, Dr. Hornyak, to continue the order of the presentation with her topic. Dr. Hornyak, the screen is yours.
Thank you very much. Can you hear me?
Yes, definitely. But everything is okay.
Something went wrong with my camera. I don't know. Can you see me?
No.
No. I don't know what's happening because in my settings, I see that my camera is working. So is it a problem if I make it only with my voice and with my PPT, this presentation?
No, we are waiting for your PPT.
Okay. Just a moment. Can you see my
Yes.
first PPT? Okay.
Yes, you can see, and in a perfect version.
Okay, thank you very much. Today I would like to speak about the transfer of agricultural holdings in Hungary. And I previously mentioned this topic and this new legal institution in the previous Open Scientific Seminar. And now I would like to focus only this topic. It is a very new and a very special legal institution in Hungary, that so-called transfer of agricultural holdings. And today I will speak about agricultural holdings or farms. Today it means a synonym, two synonym definitions. But now I would like to speak about the new act which regulates this topic. It is in force from 1st January 2023. This is the Act on Transfer of Agricultural Holdings. It's a partly cardinal act according to the Article P of the Hungarian Fundamental Law. And when I speak about the basic rules about this act, I have to say that this is a special law, a special act, so-called lex specialis, compared to the Land Transfer Act. I already mentioned this Hungarian Land Transfer Act. Maybe I can say that this Land Transfer Act is the basic of the Hungarian agricultural land regulation. And now we have some kind of acts that are regulating the transfer of agricultural holdings or this holding situation. So maybe we can say that we are in the way of a classical holding regulation. And today I would like to speak about this this act on the transfer of agricultural holdings. But I have to say that this act regulates not all the transfer situations which the subject of which is the agricultural holding. It's only applicable a very special legal transaction. So it's only though. So we can apply this act only those cases when the subject of the transfer is an agricultural holding. Maybe it's a better definition, the farm category. And the main aim of this act is to facilitate the generational change in the family. So this act would like to make easier the transfer of the ownership of the holding between the relatives, between the family members. So we can say that this is a legal institution inter vivos. And the basic aim is to make a little bit easier this whole procedure and lighten the administrative burdens. So I mentioned earlier this definition of the farm because this act called the agricultural holding as the farm, and this is this category is means the set of assets. So it means that the farm is the set of the assets when we can see here in this slide. It means in the farm, we can say it is in the farm, the agricultural and forest land, the other immovable properties, the movable properties, rights in rem, share in the assets, and rights and obligations. But now it's very important for us that some of the specialties is in this act, that the subject of this transaction are very limited. It means that there are two subjects, the transferor and the transferee, and both the transferor and the transferee must be primary agricultural producers or individual entrepreneurs engaged in agricultural and forestry activities. This is the basic rule, and after that we have to speak about the detailed conditions, because it's a very important element of this act. So who can be a farm transferor? As I already mentioned, he or she has to be a primary agricultural producer or an individual entrepreneur. The other very important condition is that he or she has reached the age limit for retirement, or he or she will reach it within 5 years from the conclusion of the contract. And the transferor has been engaged in agricultural and forestry activities or secondary activities in his own name and at his own risk for at least 10 years. And if the transferor is the user of the land, it has to be make this condition that if he is a land user of more than 3/4 of the agricultural and forestry land area specified in the farm transfer contract, has to be registered in the land use register for at least 5 years. And the other condition is that the legal heir of a primary agricultural producer or individual entrepreneur can be also a farm transferor who meets the conditions specified in this subsection A and B. So it means that the heir, the legal heir of the primary agricultural producer can also be a farm transferor. So these are the conditions. And now I would like to speak about the other subject of the transaction, who is the farm transferee. And there are, of course, other conditions that who can be a farm transferee. So it will be the young person of this transfer. And the act says that the farm transferee has to be under 50 years old and at least 10 years younger than the transferor. So it means the generational change in this transaction. Of course, I already mentioned this basic element that the farm transferee can be a primary agricultural producer or an individual entrepreneur. And it's very important that the farm transferee has to meet the conditions prescribed by the Act for the operation of the farm. And another condition is that the farm transferee has to be in the chain of relatives with the transferor, or he has to be an employee by the transferor for at least 7 years. So between of these two categories have to choose the transferee. So a relative can be a farm transferee, a relative of the transferor, or someone who are in the employment relationship with the transferor for at least 7 years. And another very important condition, that only one person can be the transferee. This rule is because of we would like to prevent the creation of undivided common ownership of agricultural holdings. So this so-called transfer contract of the agricultural holding or the farm transfer contract, we can speak about 4 types of this contract: the farm transfer sale contract, the farm transfer gift contract, the farm transfer maintenance contract, or the farm transfer life annuity contract. There are some special rules for these contracts, of course, not only the basic rules we have to apply. So I mean the basic rule of the sale contract. Of course, we have to apply this on this farm transfer contract, but of course there are some special rules in this act for these contracts. And it's very important that there are one more possibility in the act. It means that the transfer of the land, and I would like to highlight that not the farm, but only the transfer of the land use, it can be in this farm transfer contract. So we have four types of the farm transfer contract, and in these contracts we can also mention the transfer of land use in this contract. For example, lease or gratuitous land use. There are some other specialties for this farm transfer contract. One of them is that when we speak about farm transfer gift, maintenance, or life annuity contract, in these contracts, only close relatives can be the parties. So an employee can not be the party of the farm transfer gift, maintenance, or life annuity contract. And as I already mentioned, the Land Transfer Act is the background act for this Farm Transfer Act. And in this Land Transfer Act, we can see some special rules for this farm transfer contract. For example, in the preemption right and in the pre-release right, because the Land Transfer Act says that the preemption right shall not apply to the transfer of land by a farm transfer contract, but we have to highlight that here it's very important to make some strict guarantee rules to ensure that the farm transfer contract is not misused by the contracting parties, because we shall not apply the preemption right in this case. And the other special rule in the Land Transfer Act is that the pre-lease right shall not apply to lease arrangements realized by way of transfer of the right of use of land under a farm transfer contract. Another specialty by this legal institution is that there are another possibility, and it means this cooperation period. So this cooperation period is not an obligation, it's only a possibility which can choose the parties, so the transferor and the transferee. So it means that in this period, the transferor and the transferee will jointly operate the farm. It can be maximum 5 years, and the transferor will remain the owner of the agricultural holding, and the transferee will be personally involved in the operation of the holding. And they will be jointly entitled to manage the holding and take the management decisions together. And the last day of the cooperation period will be the date in which the transferor transfers the ownership of the agricultural holding. So it means that all elements of the holding or the right of use of the agricultural land to the transferee. So it can be maximum 5 years, but they can a little bit shorter time also make in this farm transfer contract. And after that cooperation period, the transferee replaces the transferor in the civil law contracts relating to the element of the farm as defined in the farm transfer contract, without the consent of the third party remaining in the contract. And the transferee replaces the transferor as the holder of any prior authorization required for the pursuit of the economic activity related to the farm, of course, as defined in the farm transfer contract. And I would like to speak about the approval of the agricultural administration body, because the farm transfer contract must be approved by this agricultural administration body, but this approval, it's not the same as the approval of the agricultural administration body according to the Land Transfer Act. It's a little bit different, maybe a little bit easier, but of course, as you can see in this slide, there are some rules in the Land Transfer Act for this approval, and there are some rules in the Farm Transfer Act for this approval. So it means that the approval is, so we need the approval of the farm transfer contract, but it's not the same as the approval of the Land Transfer Act. And for this approval, we can see in Land Transfer Act that this approval is not required. Which approval is regulating in Land Transfer Act for the transfer of land by a farm transfer contract, and also not required for land use agreements realized by transfer of use rights in a farm transfer contract. So it means that in the Land Transfer Act, there are this obligation that this contracts for the transfer of ownership of agricultural land or the transfer of the land use normally is an obligation to approved by the administration body this contract. But if this land is a part of the agricultural holding and we make this farm transfer contract, this approval, according to the Land Transfer Act, is not required. It means that the land as the part of the farm is excluded by the legislation, by the legislator from the special approval of the authorities, and the approval of the farm transfer contract is sufficient in this case. And I can say that it will be a little bit some kind of holding regulation. So it means that that can be in a holding regulation in a classical sense, maybe in the future in Hungary. But in the Farm Transfer Act, we can see that the farm transfer contract must be submitted to the agricultural administration body for approval within 60 days of its conclusion. And the whole procedure will be a little bit different as the approval of the Agricultural Administration body according to the Land Transfer Act. And I would like to highlight only one interesting question, which is the question of the legal title, because there are two different opinions in Hungary. According to one opinion, since the farm transfer contract has been introduced as a new legal institution, it means that the farm transfer has also been introduced as a new legal title. But other point of view is that the appropriate type of the contract will determine the legal title of the transaction. For example, sale, gift, maintenance, or life annuity will be the title of the transaction and not the so-called farm transfer. I share this opinion, and in my opinion, the legislator should clearly indicate in the Farm Transfer Act or in the Real Estate Registration Act if it intends to make the farm transfer as the title of acquisition. Otherwise, I think the title of the transaction is the appropriate type of the contract. So sale, gift, maintenance, or life annuity. So I think it's a very good opportunity to the family members to make it easier to make this generational change and the transfer of ownership of the whole agricultural holding. It's a good institution. It's a good new legal institution. And maybe it can be the future some other Central European countries as well. Thank you very much for your kind attention.
Thank you so much for your presentation. And now, focusing or as to the concept of our research team, I would like to provide the opportunity for Dr. Strasala to deliver his presentation.
Thank you very much. Can I ask if you can see the presentation and can you hear me?
Yes, no. Sometimes yes, sometimes no. At this moment it's a black screen, but previously there were a kind of flashlight.
Okay, so you can hear me, but the presentation is blank.
Yes, sometimes. Now okay, now not. Now okay, now not. I don't know why, but there is a kind of vibration.
Okay, I believe I can't do anything about it. Can I proceed?
Okay, maybe if it's not perfect, but you can start it on a via a verbal form, an oral form. Sorry.
Yeah. So thank you, dear professor, dear colleagues, and other attendees. Today, I would like to share some remarks on the final topic in this first field of our research, in the field of the agricultural holding and agricultural land in Poland, especially its transfer about the inter vivos or mortis causa. This last topic is the cessation of the co-ownership of agricultural holdings in Poland. And to start with some preliminary remarks. When we own a very small share in the agricultural land, we can still become the sole owner of the agricultural holding or the agricultural land. due to the cessation of the co-ownership of this estate. So this even in the situation is that we are already co-owner of the agricultural land, the acquisition and becoming the sole owner is still subjected to the restrictions in the Polish law, especially in this famous regulation of the UQUR, upon which we dealt and talked through the previous presentations. So as far as legal provisions are concerned, they are divided into two main legal acts. The main provisions about the abolition of the co-ownership are regulated in the articles 211 and 212 in the Polish Civil Code, here in abbreviation KC. There are also in the Polish Civil Code special provisions regulating exactly the abolition of the co-ownership of the agricultural holdings. It has the articles 213 to 2018, and there is a separate regulation in the law on the transfer of the agricultural land, abbreviation UQUR. Even there is some disambiguity, because when we think about the acquisition of the agricultural land, the main legal titles or legal contracts that we can think of is probably the sale contract or the donation contract or other types of legal events. The scope of the UQUR is so broad that also this change in the shares in the ownership of the agricultural holdings, what I mean, the change from the share in the one share within the other co-owner of the agricultural holdings and becoming the sole owner of the agricultural land, is still in the scope of the UQUR. So we need to look through this regulation, and if we do not find any exemption to this situation, we will still be subjected to all the restrictions derived from the UQUR. So to start with some general rules from the Polish Civil Code. In the first article, we have the right to demand the cessation of co-ownership. This right can be limited by the agreement among the all co-owners of the rest of the estate up to 5 years. So, and it can be agreed to more 5 years period, but not more in the one contract for more than 5 years. It can be postponed, this right to demand abolition of co-ownership. We can find in the regulations in the Polish Civil Code the explicit reference to the UQUR in the general provisions about the abolition of co-ownership. It is included in two articles, in articles 210 and 213. The first one is the general article, and the second one is in the part regulating the abolition of ownership of the agricultural holdings. When we compare, I believe this is important, when we compare the scope of this reference and the Polish Civil Code, this is the first excerpt here in the in black font, you can find that this reference consists and deals with the agricultural land as well as agricultural holdings. The second paragraph, the second excerpt, is from the UQUR, and this regulation deals only with agricultural land. So there is some disambiguity or a discrepancy between the regulations in the Polish Civil Code and the UQR, because the scope of the UQR is only acquisition of agricultural land. However, if we can reference to the definitions presented in the first Open Scientific Seminar, we will find that the agricultural holding, the one important element of the agricultural holding, which is a must to create the agricultural holding, is the agricultural land. So this ambiguity can be resolved through the proper interpretation of these two terms. Generally, we can abolish the co-ownership by two legal events. The first legal event is the agreement between the co-owners who decide what will be the result of this abolition, whether we will divide the property between or amongst them, or there will be a sale at the auction, and the owners will divide the income from this public auction or other form of the abolition. And the second legal event is the decision, the judgment issued by the court and special legal proceedings, and there are some regulation in the Polish code of civil proceedings that deals with the abolition of the co-ownership. Going through the special regulation on the agricultural holdings. When we refer to the above-mentioned rules of the Code of Civil Procedure, what is important that the motion, lawsuit, is binding to the court if all co-owners or parties of the proceedings agree to the way of the abolition. So where all parties, all the co-owners decide that they want to, for example, divide the land, the estate, the property between them, this motion and this form, this kind of abolition is binding the court. As we look in the regulation about the agricultural holdings, it is not the same, because in the case of the agricultural holding, if the abolition of the co-ownership by the physical division among the co-owners will result in the effect that is contrary to the principles of careful agricultural management, the court is not bound by the motion, and the court should take into account the rules of the proper agricultural management and decide on a different way of the abolition of the co-ownership of agricultural holdings. So these rules in the Polish Civil Code, which prefers a physical division, because when we the code is bound formally in two issues. One is the the consent of all parties about the way of the abolition, and if there is no consensus between them, the code is bound by the preferable ways in the Polish Civil Code. The preference of the Polish legislator is like the following. The first, we will divide the property. Next, we will grant the full ownership to the one of the parties. And if that is not the case, the last way, the less preferable way of abolition of the co-ownership is the public auction and the division of the income got from the auction. In these two ways, there are exemptions for the agricultural holdings. The first one was described above, and secondly, the court is also not bound by the this I may say the three the sequence of division of the abolition of the ownership. In the special regulations of the Polish Civil Code on the division, the abolition of the co-ownership of the agricultural holdings, there are one important special regulation. There is a possibility for reducing payments of the pecuniary equivalent of the shares. It is the case when the some of the co-owners do not acquire a part of the estate, and they should be paid off by the one who became the sole owner of the land. And in the case of the agricultural holdings, this amount of the money they should get can be reduced due, for example, to the income that can be produced by the agricultural holdings. And second part of the regulation is the rules of the UQR. And today there is no doubt that the abolition of the co-ownership of the agricultural holdings or agricultural land is subjected to the rules of the UQR. There is an exemption made from the general rule of the UQR. The general rule of the UQR is that the acquirer of the agricultural land must be an individual farmer. And in the case of the abolition of co-ownership, there is an exemption in Article 2A, paragraph 3.10 in the UQR. There is no need to be an individual farmer to become the sole owner due to the cessation of co-ownership. And this applies to all kinds of co-ownership, for example, co-ownership, marital co-ownership after the divorce or the death of the spouse, or the co-ownership that is the result of the inheritance. And what is important, if a foreigner, not from the EU country or not from the Swiss Confederation, there is a necessity to obtain permit from the authorities, even if that foreigner was still a co-owner to become a sole owner of the land, not only agricultural. There is a necessity to obtain the permission from the state authorities. And the last but not least, but one of the most important things, in fact, is that acquiring ownership due to the abolition of the co-ownership is still subjected to the right to acquire by the state treasury, represented by, here in abbreviation, KOWR. So when we, for example, when we want to abolish the co-ownership due to the agreement of the all co-owners, we need to inform the KOWR about our idea to abolish that. And this institution, this state institution, can issue a declaration of will that they want to buy this agricultural land in the name of the state treasury. There are, of course, there are some exemptions, and one of the exemptions deals with the close relatives. However, there is no exemption in the regulation of this right to acquire agricultural land by the KOWR. We still can freely can be free to acquire agricultural land only by our own decisions and legal acts. So to summarize the three main points, in Polish Civil Code there are provisions on the cessation of ownership of agricultural holdings, and these provisions especially protects agricultural value of the agricultural holdings by introducing special rules concerning preferred ways, and introducing the rule that the court is not bound by the motion in the legal proceedings for the abolition of joint ownership. The second most important thing is the acquirer of the agricultural land does not need to be an individual farmer. And the third, I believe, in practice, the most important thing is that becoming the owner, the acquisition of the agricultural land due to the cessation of ownership is still subjected to the state treasury rights. Thank you for your kind attention. I hope that the internet connection was good enough to hear and see the presentation. Thank you once again.
Dear Doctor, thank you so much for your contribution. It's worth noticing that we can hear everything. Therefore, I think it was absolutely a perfect presentation. However, we could not see the PPT only at the end of the, for example, of the presentation. We can see that. Thank you for your attention. But I think, however, it was.
I'm very sorry. I will send it via email.
Okay. Then okay, and thank you so much. And now. I would like to call Professor Adamus to give her presentation. To give his presentation.
I hope you can hear me. Yes. And the question
yes.
is, the next question is, can you see my presentation or not?
Okay.
I think I have some problems to show you my presentation. Just give me 1 minute. Maybe I can manage this problem. It's still working, but I cannot show you my presentation at all.
I have a specific
yes.
Rights, taking into account that I am the team leader as to this opening seminar. Therefore, I do not know whether you have a similar panel as mine. However, as I previously mentioned, at the bottom of the screen, I can see, for example, a red button, and if I click on this red button in the middle of screen, I can choose from options.
Yes, but it's still working. It's showing that something is going on proceeding. So
okay, but there is if there is a panel, you can choose from different options whether to use Microsoft Edge, for example, or Windows. And when I choose window, in this case, I can select a window which representing my PPT. Maybe that's the option.
Perfect.
Okay. Now we can see your presentation, but in this case, this is a small one. Maybe you should start the broadcast. Yes, that
Thank
is.
you very much
Yeah,
for your
everything
help.
is perfect. Everything is perfect, Professor.
Thank you so much. Thank you so much. It was my mistake. I am technically disabled. I'm sorry for that. So today I'd like to say something about preventing farmers' bankruptcy in Poland. I have some proposals to improve some regulations which are probably not well prepared in order to help farmers in case of their bankruptcy or threat of bankruptcy. As a second part of my, just a second. As a second part of my research, I'd like to present proposals for necessary changing of insolvency law in order to protect farmers against some serious problems connected with insolvency or the threat of insolvency. I'd like to start with saying some sentences about the types of insolvency proceedings in Poland, about the system of insolvency law which is in force right now. Generally, we have two kinds of proceedings. There are bankruptcy proceedings and restructuring proceedings. All of them are available for farmers who are natural persons. However, in case of bankruptcy proceedings, we have two types of such proceedings. The first is for entrepreneurs and the second is for consumers. And under regulation of the Polish law, farmers can start only consumers bankruptcy. It's a very good solution because consumer bankruptcy is much cheaper, is much safer for farmers than regulation of bankruptcy designed for entrepreneurs. And in case of restructuring proceedings, farmers have ability to be a part of any of them. In fact, we have 4 proceedings connected with the possibility of concluding the arrangement. And they are quite different as we can start with proceedings for approval of the arrangement. This procedure is a very specific one because all is going not in the court is only in the last stage of the proceedings. The job of the court is to approve of arrangement concluded by creditors and the debtor himself, not before the court. The next 2 proceedings are quite similar. I mean, accelerated arrangement proceedings and arrangement proceedings. And last restructuring proceedings are very specific. There are hybrid proceedings because they have some elements from bankruptcy law and some elements from arrangement proceedings. However, a farmer who is a natural person can be a part of any of the restructuring proceedings, and I can repeat it one more time. In case of bankruptcy, the farmer can choose only a consumer bankruptcy, which is a very good solution from the position of his rights and duties in bankruptcy law. Now I'd like to pay your attention into pages of the restructuring proceedings because my proposals are connected with some of them. First, of course, we should mention motion for opening proceedings, court's decision on opening proceedings, and establishing the list of debts. The characteristic part of this stage for restructuring proceedings is voting for or against the arrangement. After that, we have a stage of court's approval of the arrangement and fulfillment of the arrangement as the next stage of the proceedings. It's very important that a debtor can make some changes to the arrangement. In practice, it happens that arrangement is going to be fulfilled for many years. Something unexpected could happen. So in such circumstances, there is a possibility of changing the arrangement proceeding, but in fact it's very complicated because any person, a creditor or the debtor, if he is willing to change the arrangement, she should or he should start from the beginning. So he should fill the motion for opening the proceedings, wait for the court decision, vote for or against the arrangement, and wait for court's approval of the arrangement. In fact, it's a very expensive solution. It takes a lot of time, and I think we could find some better solutions for such problems. The next issue is about stages of bankruptcy proceedings. They are quite similar to the stages of restructuring proceedings. However, there are some major differences. We start with motion for opening proceedings. We wait for court's decision on opening proceedings, establishing the list of debts, and what is the big difference between bankruptcy and restructuring? Liquidation of the bankrupt assets made by the trustee. After the assets of the bankrupt are liquidated, there is the stage of satisfaction of the creditors by the trustee. And after the bankruptcy proceedings are closed, there is the possibility of so-called debt relief for a natural person. If the bankrupt has no assets after bankruptcy proceedings, but he is still liable to the creditors, it's possible to rid of his liabilities by the ruling of the court. In such circumstances, the court appoints a special repayment plan, and after the repayment plan is fulfilled by the bankrupt, there is a possibility for debt relief for the bankrupt. And this is a very good solution because bankruptcy proceedings is the procedure which could give to the debtor freedom of his or her debts. And coming straight to my proposals, I'd like to mention that some of them are only for farmers, and some of them should be general, and inter alia they are designed for farmers, but also for any kind of debtor who is involved in bankruptcy or restructuring proceedings. My first proposal is about limitation of formal requirements in case of farmers' motion for bankruptcy or restructuring. In present regulation, I think that applications submitted in restructuring and bankruptcy proceedings are the most complicated in the Polish civil law. I think that limitation of some formal requirements in case of farmers' motion is quite a good idea. Farmers are not to produce so many documents as entrepreneurs do. They have very simple accountancy. So if we can allow the farmers not to fulfill all formal requirements designed for entrepreneurs, I think that we could help them in using in practice those proceedings. My next proposal is about facilities for a farmer, including an arrangement. Some arrangement proposals could be binding automatically. The idea of the amendment is the following. If the arrangement proposals are for farmer who is a natural person and do not stipulate otherwise, all costs of proceedings, costs of enforcements, including lawyers' fees, all the interest due to not fulfilling financial obligation in time should be fully terminated. So if, for example, a farmer doesn't know about the possibility of such kind of proposal for arrangement, he simply forgets about such proposals. They will be binding by virtue of law. I think that it's a very useful idea for farmers and it should be probably carefully discussed. The next proposal is about granting for farmers the right to suspend the fulfillment of the arrangement which is in force. There are no rules de lege ferenda right now, and I think that de lege ferenda in future, farmers who are natural person should have the right to suspend fulfillment of arrangement with creditors by virtue of special statement prepared by the farmer himself. Such a statement should be made in writing with a definite date. It should be delivered to the court, to the supervisor of the arrangement implementation, if such a supervisor has been appointed, and of course to the creditors who have outstanding arrangement claims. In such a declaration, the farmer should indicate the reason for preventing the implementation of the arrangement, and of course the suspension of implementation of arrangement should be granted for the specified period of time. I think that we should discuss 3 or 6 months for suspension of implementation of the arrangement. I think it's not harmful for the creditors, because if we start special formal procedure in order to change the arrangement, I think it takes months or sometimes even years to fulfill all requirements of changing amendment which was concluded in restructuring proceedings. So I think that such proposal could first be faster than traditional manner of changing the arrangement, and secondly, it will be much cheaper for creditors and for debtor to use such a very simple tool in order to change fulfillment of the arrangement which is in force. I have, I think, quite similar second proposal connected with changing the arrangement. The present proceedings are quite complicated. Shall I repeat that we should put the motion to the court, wait for the court's approval, submit proposals to the court of changing the arrangement. We should have time for voting for the changes or against them, wait for court's approval of the amended arrangement, and wait for the fulfillment after the ruling of the court is final. My second proposal, or the next proposal, should be very simple, because if there are no objections of proposals of the debtor to change the arrangement, the changes should be enforced automatically. What are the details of this proposal? If there are conditions for changing the arrangement, the farmer should announce the content of the changes to the arrangement. And I think that within a certain period of time, creditors whose claims would not be paid could lodge objections. They are not obliged to do this. And if the creditors' objections exceed, for example, 1/3 of all outstanding claims, then the change would not be effective. Approval of the change in the content of arrangement will take place at the end of a certain period of time, automatically, with no court's ruling, which is very complicated in fact, in practice. I think that court intervention would only be needed in objection if an objection was lodged by the creditor. The problem in the Polish judicial system is the following. There are many bankruptcy cases which are submitted to the courts. The courts are overloaded with such cases, and I think that any simplification of the proceedings should be very helpful for the time which is essential to deal with the case in bankruptcy or restructuring court. The next proposal is about changes in bankruptcy law. The idea of the proposal is the following. Before using this new regulation, if the farmer is insolvent and if he is the owner of the agricultural holding, probably it should be a possibility for the state treasury to buy the farm from the trustee. I think that the cost of such operations should not be very large, but I think that this solution will be very helpful for many farmers. And after the agricultural holding is bought by the state treasury, the farmer, under the special agreement between the state treasury, could be the tenant of the agricultural holding which he owned before bankruptcy, and the state treasury could be the owner for a specified period of time, and of course, the farmer could be given special preemption rights in order to buy this agricultural holding in the future. The detailed proposals are the following. First, you should start with the public law, and with the limits of the annual limits set by the state budget, the state treasury should be able to buy the agricultural holding from the trustee. The acquisition would be free from any mortgages, as it's usually in bankruptcy sales. And the state treasury would list the farmer the acquired agricultural holding for a fixed period of time for a fixed rent, with the right of preemption of the agricultural holding given to the farmer. In case of former owner's declaration of acceptance of lease his agricultural holding, in addition, I think we could discuss the possibility of giving the farmer some more advantages. For example, a farmer who is a natural person could be free from rents for 6 months. A farmer who is a natural person should receive appropriate amount for sowing from the selling price of his agricultural holding. And such regulation will be a very good solution for farmers who are insolvent. They will stop to be owners, they will be just tenants, but probably in some years they could buy the agricultural holding back from the state treasury. And the next but very important proposal is connected with debt relief. I think that in the present legal system in Poland, we have no equilibrium between individual enforcement conducted by the bailiff and the bankruptcy proceedings conducted by the trustee. In case of individual enforcement, a debtor has no chance to be free from his liabilities, but after bankruptcy, it's possible to get debt relief. So bankruptcy proceedings are much more advantageous for debtor than individual enforcement. And in practice, we have such situation that a debtor, for example, a farmer who is a natural person, is under individual enforcement. The bailiff is going to sell his agricultural holding, and the farmer remains with liabilities which are not covered by the price received by the bailiff. In such a case, a farmer should start bankruptcy proceeding, but it's useless because of this, but he has no assets. And I think that proposal, which will be very helpful for the farmers, is the following. If the bailiff sells out all assets of the farmer, he should give to the farmer special declaration that the sale was about of his all assets, and the farmer could start special procedure before the civil court in order to cancel undercover liabilities after selling all his assets by the bailiff. And in this situation, I think we could get equilibrium between bankruptcy proceedings and individual enforcement conducted by the bailiff. And I think this proposal would be very helpful for reducing the number of bankruptcy cases in bankruptcy courts. And I think that this will be very helpful for farmers in order to get debt relief much earlier than in regulation, which is present in the de regulata legal system in Poland. I think that it's all I have prepared for today. Thank you for your attention.
Dear Professor, thank you so much for your thoughtful presentation and ideas via your presentation. And last but definitely not least, I would like to call my Hungarian colleague, Dr. Csirszky, to deliver his presentation.
Thank you very much. Can you hear me and can you see my presentation?
Definitely.
Oh, okay. So thank you. My last presentation was about a broader perspective because I tried to speak about some policy issues and from a broader viewpoint. However, today I would like to go into details in connection with anti-competitive agreements and unfair trading practices, and I would like to touch upon a few European aspects of these topics, and my last and next presentation will be about my academic article that will be written in a short time, and the topic of that presentation, so the next one will be about the sustainability agreements and its competition law and their competition law assessment, and I hope with these presentations I will fulfill my research completely. So the central question is still the same, that how does competition-related regulation protect agricultural producers against the mentioned problems that I have already told about during my earlier presentations. And as you can already see that the agricultural policy with producer welfare at its core wins over competition policy, and there are many exemptions and exception rules concerning the agricultural sector, both at national and EU level. And this comes basically at EU level. This comes from Article 42 of the Treaty on the Functioning of European Union, because it basically says that that the competition rules are, I would say, inferior to the agricultural policy objectives, and these agricultural policy objectives are inter alia, for example, the increase of standard of living of agricultural producers, and because of that policy objectives, there can be sector-specific and alleviating rules that make the situation of farmers more privileged. So agricultural policy is the winner, and this chart was also shown at my latest presentation. And as I told you, my latest presentation was about more broader perspectives, and now I will concentrate on the specific rules that are about conducts related to anti-competitive agreements. And my other topic today will be those of the conducts related to unfairness. The Hungarian system basically builds up on an ex-post protection system with a limited antitrust exemption and the prohibition of unfair trading practices. And as you can see, both the European Union and Hungary have certain provisions that aim to protect the agricultural producers. As I said, Article 42 TFEU is the basis of the whole derogation for the sake of protecting agricultural producers, and the EU secondary law provides the detailed rules in Articles 206 to 210 of the Common Market Organization regulation, as well as in the Council regulation coming from 2006. However, in Hungary, the basic rules for the limited antitrust exemption from the prohibition of anti-competitive agreements is codified in Section 93A of the Hungarian Competition Act. It is a difference between the two regimes because the European Union regulates the whole issue, I would say, in an agricultural legal source. However, in Hungary, the detailed rules are codified in our Competition Act, but this does not tell us much about the nature of these provisions, because I would say that the Hungarian provisions are much more protective, as regards agricultural producers. You can see that in the European Union, I did not show any provisions related to relative market power. However, in Hungary, in the so-called Trade Act, there are some provisions, but I must mention that these provisions do not cover primary agricultural production, but certain foodstuffs, and there are some alleviation for small and medium-sized enterprises against bigger companies, and the whole situation is built upon the legal instrument of relative market power, which means that although concerning the whole market, the undertaking does not have absolute market power, but relatively with its trading partner, it can, I would say, enforce certain relative market power and can choose certain contract terms that are detrimental to the weaker bargaining party. And the third group is about unfairness. The Directive 2019/633 covers the situation of unfair trading practices, the system of unfair trading practices that has been implemented by all member states. However, I must mention that Hungary has already had a full act dedicated to cover unfair trading practices in the agriculture and food sector, and this is Act 95 of 2009. And this Act 95 of 2009 is a lex specialis in relation to the Trade Act. However, it comes from a different approach because it aims to combat expressis verbis unfair practices, and the whole Trade Act is built upon more on competition law terms, while the sector-specific rules in Act 95 of 2009 are more fairness-based. And this is one reason that competition lawyers criticize this fairness approach concerning the agricultural sector, because they say that these rules lack efficiency and make the situation worse than in the lack of these rules. So as I mentioned, that the antitrust exemption, which is related to the prohibition of anti-competitive agreement, is codified in Section 95 of the Hungarian Competition Act. And you can see on my slide the text of these provisions, and it is quite quite different from the EU rules, because it declares that in relation to an agricultural product, the prohibition of anti-competitive agreements shall not be deemed to have been infringed if the distortion, restriction, or prevention of competition resulting from the agreement does not exceed what is necessary to obtain an economically justified and fair income, as well as the market participant affected by the agreement is not prevented from obtaining such income. And it is very unique because the agricultural minister shall determine whether these conditions for exemption are fulfilled. However, I must say that the exemption has already been applied twice. Once the agricultural minister decided that that the conditions for the exemptions are existing and they are valid. However, in another case, it ruled that that the exemption cannot be applied by the Competition Council. The reason for the latter one, that was when the agricultural minister decided that the antitrust exemption cannot be applied, was that it was about a public procurement cartel, and because of the agricultural producers' anti-competitive agreement to fix their prices in the public procurement, the agricultural minister decided that that the other market participants affected by the agreement were prevented from obtaining the income. However, in the first case, the situation was different, because there was, I would say, a whole and from a competition law perspective, a quite restrictive agreement between, on one hand, agricultural producers, and on the other hand, the agricultural ministry, that the Hungarian watermelons should be sold at least at 100 forints per kilogram. The reason for the decision was that when the imported watermelons are coming to Hungary in the middle of summer, most of the retail chains, which are, I would say, transnational companies, they will decrease the prices of Hungarian watermelons so much that the producers cannot even reach an economically justified and a reasonable income. So the agreement was about, I would say, to solve this problem, and the Hungarian agricultural ministry would have liked to help agricultural producers. And because of the reason that the whole watermelon market could obtain the income that came from the, I would say, basically anti-competitive agreement, the minister decided that the antitrust exemption can be applied. This whole procedure was highly criticized from a number of persons and institutions. However, I would say that that the basic justification for the whole provision is I think serves a good cause, and basically the decision which exempted that anti-competitive agreement aiming at fixing watermelon prices resulted in the situation, and the agriculture minister's opinion resulted in the situation that the Hungarian Competition Authority terminated the proceedings and decided to not impose fines based on the opinion of the agricultural minister, which is actually binding on the competition council, as you can see on the second paragraph. There are some procedural rules concerning the antitrust exemption, and one of them is that the minister shall issue the opinion within 60 days of receipt of the request from the Hungarian Competition Authority, during which period the Hungarian Competition Authority shall suspend its proceedings. Furthermore, the Competition Council shall suspend the imposition of a fine in the case of an agreement contrary to the prohibition of anti-competitive agreement, where the violation has been committed in relation to an agricultural product. So, in such a case, the Competition Council shall set a time limit and require the parties to the agreement or concerted practice to bring their conduct into conformity with the provisions of the law. So, even if the agricultural minister finds that the conditions for exemption are not fulfilled, even in that case, the Competition Council has an obligation to suspend the imposition of fine and provide the possibility for the farmers to bring their conduct into conformity with the provisions of law. So basically, if they seize their anti-competitive agreement, they cannot be fined because of the earlier agreement. One important experience that came from these two cases that, and I would say one important conclusion, that the Hungarian Competition Authority is not fully active in the agricultural sector, and I would say that it aims to provide protection for the agricultural producers. However, we have to take into account the whole justification behind this approach, which comes from EU primary law that declares that agricultural policy objectives are given preference over competition rules. Turning to the system of unfair trading practices, I must mention that unfair trading practices are a kind of helping hand for those situations when the dominant position cannot be found from a conventional competition law sense, and it provides much active protection for producers because of the easier enforcement mechanism. The system of unfair trading practices is supervised by the Hungarian National Food Chain Safety Office, so it is not a competence for the Hungarian Competition Authority. Basically, the act which implemented and which has already existed before the European UTP directive is built upon a general norm and the blacklist in Hungary, and the general norm declares that unfair distribution practices are forbidden. I would say it is without function, because it cannot be called upon when the National Food Chain Safety Office would like to go after a conduct which is not covered by the blacklist. Blacklist means that the practices which are included in the blacklist are forbidden without any more assessment. I would say per se forbidden practices. So, and the gray list is a requirement or a possibility that came from the UTP directive, and it is not used by Hungarian legislation, and it is not included in the Hungarian Act. It means that if the parties, the agricultural producer and its buyer agree clearly and unambiguously about a certain practice, then the unfair trading practices, the prohibition of unfair trading practice is not enforced. However, the Hungarian system does not use the so-called grey list method. All practices that are regulated are so-called blacklist practices, and it provides a much more ambitious protection to the farmers, because basically the problem with the grey list is that the superior bargaining position of the buyer can be misused the same way by the buyer against the agricultural producers. So grey list is, if we were to use the grey list practices, it would look like that it's a non-existent and a non-protective pillar of the whole system, because the root of the problem is not handled in relation to grey list practices. The Hungarian blacklist practices, as you can see, there are twice as many conducts in the Hungarian blacklist than in the Unfair Trading Practices Directive. Basically, this comes from the practices that are grey list practices in the UTP directive, and they are regulated as blacklist practices in Hungary. And there are also some examples of Hungarian blacklist practices that are not mentioned by the UTP directive at all. For example, when the trader passes on to the supplier the costs resulting from a penalty imposed by a public authority on the trader for an infringement of the law within the trader's sphere of activity. For example, any kind of authority would fine a big retail chain, and the retail chain would say that this fine is related to the product of the agricultural producers that I bought from that producer earlier. That's the reason I pass on to the supplier the costs that result from this penalty. A second example is that the trader lays down that the supplier shall provide a discount to the trader if the trader payment takes place in accordance with the payment deadline. It's quite a ridiculous provision, but there were many times when the National Food Chain Safety Office found contract terms that had a provision and that had a contract term which declared that a discount shall be paid by the agricultural producer to the trader if the trader fulfills its conventional and totally normal payment obligation. And the third one is that the trader offers the product to final consumers at a price lower than the price indicated on the invoice issued by the supplier. So furthermore, there are more differences regarding the formulation of certain practices. In connection with the late payment, there are stricter Hungarian provisions than the one required by EU law, and irrelevant whether the delivery is regular or irregular, the late payment provisions apply to the same way. And also irrelevant whether perishable or not agricultural products are at stake. So of course, the European provisions provide for a more privileged provision for perishable and a less privileged provision for not perishable agricultural products, and the Hungarian provisions treat these perishable and non-perishable products in the same way, and the late payment provisions are the same as regards these products. And Furthermore, there are clearer benchmarks and starting points for deciding whether the payment is lawful or unlawful. So I would say that the Hungarian provisions are much better in this regard. Furthermore, certain threatening practices by the buyers. In Hungary, it is prohibited when the different types of threats take place in order that the trader could reduce the purchase price despite the supplier's objection. Furthermore, as regards written confirmation, when, for example, the agricultural producer asks from the trader that the contract be formulated in writing, so it is also quite, I would say, ridiculous that there are certain contracts between producers and buyers that are not in written. However, these happen in business transactions. So the written confirmation in the Hungarian regulations intervenes in a later stage, but I think that it effectively prevents any misuse by traders. Overall, I would say that the whole Hungarian system of the protection of farmers in business transactions are at a much higher level than the one required by EU law, and I think we are much better at protecting farmers in contrast with other member states. So I would say that the whole regulation which has been adopted 10 years ago in Hungary, and it was continuously developed, fulfills the obligation coming from the protection of agricultural producers. There are some fine-tunings that could be further polished, but I think overall the Hungarian system is a system that could serve as an example for other member states, for example Poland, and there are very good enforcement experiences in Hungary, and basically I would say that the Hungarian regulation could not be extended to a much more protective way, because if we would do that, it would go against EU law. So thank you for your attention, and that was my presentation for today.
Dear Dr. Chiscu, thank you so much for your presentation. That was our fifth open seminar, and now we are preparing, first of all, to finalize our article, and we are prepared for the sixth, we can say the last open seminar. As far as I know, we are going to arrange it on 3rd October. Please do not forget it. And a technical information, please do not forget to send me your monthly report, if it is possible, by the mid of tomorrow, taking into account that I have to make some arrangement to be posted, these monthly reports to be posted in time. Dear colleagues, thank you so much. If you have, of course, any question, please do not hesitate to do that. If not, in this case, I think it is high time to say goodbye and have a nice evening.
Thank you very much, dear Professor. The same to you.
Thank you.
Thank you.
Bye.
Bye.
Goodbye.
Bye.